Charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Court is calling 2024 CR 012116, State versus Jose Ovidio. Could I have parties announced for the record? State,
Rick Banion for the state of Texas.
defense.
Ron Ross.
And how do you pronounce your last name, sir?
Oviedo.
Oviedo?
Oviedo.
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 Okay, thank you.
Yes, ma'am.
Counsel, have you received all discovery?
I have, Judge.
And did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, sir, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
The state proceeds on the indictment. The enhancement is waived. No objections are raised. The charge, aggravated assault with a deadly weapon, carrying a possible sentence of 2 to 20 years. The defendant's rights are explained and then waived. The plea is entered. The sentence, 2 years in prison and a fine imposed. And with one simple answer, yeah.
Judge.
State, are you proceeding on the indictment as presented?
We'll waive the habitual enhancement, Your Honor.
Any objection?
No objections to that.
All right, sir, did you review the document entitled Court Admonishments and Waivers with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon, no applications. The state will take it.
Under the agreement, the court enters an affirmative finding of family violence. A no-contact order is imposed with complainants. The defendant is advised no weapons, no ammunition, and no designation as primary custodial parent. One name is corrected for the record, and no objections are raised. The court clarifies the terms, and both the state and the defense indicate their agreement. The waiver of appeal is reviewed, understood by the defendant, and signed.
In consideration 2024 CR 012198, there's an affirmative finding of family violence, and there's to be no contact with the complainants.
Judge, that is the agreement. We were going to ask the judge to make that a no harmful contact. He has an ongoing relationship with that lady, and there's still have.
All right, let me ask you all, is this name spelled correctly? You spell it Adnrea?
Yes.
Is that the way you spell that?
Andrea, Andrea. Yeah.
Adnrea. Is that the correct spelling?
It's misspelled. I'm sorry.
What should it be? What's the spelling?
Andrea.
Any objection to the court making that correction in the plea?
No, Your Honor.
All right, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
All right, and defense, you're saying that your agreement is not for no contact, it's for no harmful or injurious
Well, it
contact?
is for no contact, but we would ask the court to make a no harmful contact. We will go by that if that's what the judge rules, but we're asking you to make that one exception because he does have a relationship with this lady.
All right, state, do you understand that to be the agreement?
That's not the agreement, Your Honor. We're asking for no contact, given the facts and circumstances of this. We ask that no contact order go forward.
All right, so they're saying that's a part of their plea bargain agreement. All right,
You want to go ahead and go with no contact with him? That's what the plea bargain is.
I mean, that's what I excited for.
Willing to go on to, okay, you can always pull back. But you.
all right, let me help solve the problem. State, will you all put this outside your agreement, the no contact?
That's no objection.
All right, so any objection to the court correcting the paperwork to be no contact with the complainants, and that will be outside your plea bargain agreement?
No objection.
State any objection? State any objection? No objection, correct?
Well, Your Honor, and Ashley Jones for the record, for one of the witnesses, it's Andrea Salazar. That one we would ask be above the line and part of our agreement for a no contact order. And I don't think that there's going to be any objection from defense on that. Isadora, we can make the order.
Yeah, we can. That's acceptable. We'll go on with that.
Okay. All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
By signing, the defendant waives a right to appeal. Only limited pretrial rulings remain reviewable, and no such motions exist. The state requests that the defendant have no contact with Isadora Balderas outside the terms of the agreement. The court is not bound by this recommendation. For count one, the defendant enters a plea of no contest. The state presents its evidence. There are no objections and no live testimony, only reports and statements. The court reviews the exhibits and finds the evidence sufficient. The plea is accepted, and the defendant is adjudged guilty. The court then proceeds to sentencing.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting no contact with Isadora Balderas. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer exhibit one with all attachments, Your Honor.
No objections, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation with testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
All right, state, have you had contact with your complainant?
In this courtroom, the law speaks plainly. Relationships are tested. Excuses are weighed and consequences are final. What follows is not merely a ruling, but a lesson about violence, responsibility, and why some relationships are meant to end.
We've attempted and didn't get any return, Your Honor. We had to leave voicemails.
All right, thank you so much.
Thank you, Your Honor.
Yes, anything you wish to say on behalf of your client with regards to the no contact?
Only he represents to me that they have an ongoing relationship. They've had one, and he asked me earlier, can I put her on my visiting list here in jail if the judge says no harmful contact? I said, yeah, I think so. And when you go to prison, you can put her on a visiting list if it's no harmful contact. So apparently there's an expectation from him that she will want to come see him. So I'm taking him at his word that they do have a relationship. I also, the phone numbers I had, I left messages and she did not call me back, so I've tried to reach out to her also.
All right.
And also,
Sir.
I point out, this is a screwdriver, not a knife, and it was swinging it around. It's a little bit different than,
All right. Sir, this is what the court is going to do. As previously stated, the court is finding you guilty. There's an affirmative finding of family violence. There's an affirmative finding of deadly weapon. There's to be no contact with Andrea Salazar and Isadora Balderas. Taking consideration 2024 CR 012198, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing. Anytime you're swinging a screwdriver at somebody or hitting somebody with the screwdriver, it gets to that point of violence in a relationship, not a good relationship.
Yes.
So your relationship with her is over. How old are you?
I am 43.
All right, so you should know better. So that relationship is over. Here's my advice to you. When you're released from the prison, don't immediately get into another relationship because you're not ready for one.
Yes, ma'am.
Buy yourself an orchid. And when you buy that orchid, it comes from the store, it's beautiful, the blooms are on it, right? It's sort of like a new relationship. Everything is new. Everybody's loving each other. The fact that somebody doesn't clean up behind themselves, you think that's so cute, right? Because it's a brand new relationship. Well, what you do is when you get that orchid, once the blooms fall off, and it will, do not get in a relationship until you're able to make that same orchid rebloom. Because when you try to get that orchid to rebloom, it'll teach you patience. Because
right.
no matter what you do, sometimes that orchid is just like, no, not blooming. You understand?
Yes, ma'am.
All right, good luck to you.
All right, thank you, John.
You're welcome. State,
The case concerned Jose Oido, a 42-year-old defendant charged with aggravated assault with a deadly weapon, a second-degree felony under Texas law. During the plea hearing, the court confirmed that discovery had been completed and reviewed the indictment with the defendant. Oido stated that he understood the nature of the charge and the applicable punishment range of 2 to 20 years imprisonment and a fine of up to $10,000. Oido entered a plea of no contest, which the court accepted. In accordance with the plea agreement, the judge sentenced him to 2 years incarceration, impose a $1,500 fine, and enter affirmative findings for the use of a deadly weapon and for family violence. The court further ordered that Oido have no contact with the named complainants and awarded credit for time already served. Due to the felony conviction and the family violence finding, the defendant was advised that he is permanently barred from possessing firearms or ammunition. Up to this point, the proceedings followed standard courtroom protocol. The moment that distinguished this case occurred after the formal record had concluded. Addressing the defendant directly and in plain language, the judge spoke candidly about the violence involved, specifically referencing the use of a screwdriver. She made clear that the relationship underlying the offense was over. After confirming the defendant's age, the judge emphasized that he should have known better. She then offered metaphor, comparing healthy relationships to orchids that require patience, discipline, and care to bloom. Her message was unmistakable. Until the defendant could demonstrate self-control and responsibility, he had no business entering another relationship. The exchange underscored the court's authority not only to impose punishment, but also to confront destructive behavior once the legal outcome had been determined.